Okay, hello everyone. Thank you so much for joining us for this small webinar that we are hosting by AK Law Chambers. So, to give you a little bit of how this is going to work is that the current video is going to be streamed live on Google page as well as on YouTube. So those of you who can access YouTube and can't access Google Hangouts, so it's easier for you all to access this particular live feed that is happening. For those who are not able to attend this thing or have to go in the meanwhile or have another can't really view the whole of the program, don't worry, because the same video is going to be recorded on YouTube and you can always go and watch that. So the program is scheduled in this way. Anirudh is going to be speaking for 50 minutes. Anirudh is the AK Law Chambers. He's the founding partner, and he'll be speaking for 50 minutes on the implications of the new ordinance on the arbitration. And after that, I will be taking on for a few minutes. I'll be speaking on the implications of the same ordinance on mediations. And then we can have a 20-minute session of just question and answers. And those of you who want to ask a question can always find a question answer app that is there on Google page. You can click on that and you can type your question, and I'll be asking those questions to Anirudh. So I think
Good evening, ladies and gentlemen. We are truly overwhelmed by the response that we've got for this webinar. Without any further introduction, let me go straight into the topic. What were the main problems that litigants faced with the Indian arbitration regime? Most people who have been through the regime under the 1996 Act prior to the ordinance would state that firstly, even though arbitration is a form of alternative dispute resolution, there is excessive judicial interference in arbitration. Secondly, there was a lack of certainty, lack of neutrality, and when I say certainty, I mean certainty in terms of costs and certainty in terms of time. One of the primary problems was the snail's pace at which arbitrations and post-arbitration litigation proceeded. With a view to overcome these difficulties and to inculcate a culture of speedy dispute resolution, the arbitration ordinance was promulgated. Prior to the ordinance being promulgated, there was a detailed study by the Law Commission which came up with a very, very detailed report, the 246th Law Commission report. By and large, the ordinance adopts the Law Commission report. However, there are certain lacunae in the ordinance which are going to give rise to a large amount of litigation, and this is primarily because the ordinance has decided to leave out certain provisions of the Law Commission report while adopting certain other provisions. Broadly speaking, the ordinance can be dealt with under 6 heads. Firstly, those provisions which are aimed at reducing judicial intervention. Second, provisions which further neutrality, certainty, and fairness. Third, provisions that provide for a carrot and stick approach which would better the culture of arbitration in our country. Next is the attempt to provide a fast-track mechanism. If you ask me, this is possibly going to be the biggest problematic area insofar as the ordinance is concerned. Fifthly, attempts have been made to encourage institutional arbitration. Lastly, I would be dealing with the flaws, primarily with the applicability of the ordinance, as in, would the ordinance be applicable prospectively, would it apply to arbitral awards that have already been passed, etc., etc. Let me jump straight into my first topic, which is judicial interventions. Under this main topic, I have 7 subtopics. I will start off with the Balco Conundrum. Let me give you a brief background. The entire issue which came up in the Balco's case was on the interpretation of Section 2.2 of the Arbitration and Conciliation Act as it then stood. Section 2.2 prior to the amendment read as follows. This part shall apply where the place of arbitration is in India. When I am saying this part refers to part 1, which importantly contains sections 9, 11 and 34. Section 9 deals with the power to grant interim relief, power of the Indian courts to grant interim relief. Section 11 deals with the power of the Chief Justice to appoint an arbitrator in case of dispute between the parties in relation to the appointment. And Section 34 provides the power to Indian courts to set aside an award. All these three are based in part 1. Therefore, the way in which Section 2.2 is worded is that if one part of part 1 would apply, the rest of it would apply as well. That is, if Section 9 applied, Section 34 would automatically follow. Because there was nothing in 2.2 to suggest that one part of part 1 can apply. The issue that came up in the Bhatia International case was whether part 1 applied when the seat of arbitration was outside India. The Supreme Court looked into the wording of Section 2.2 and compared it with the wording of Article 1.2 of the Uncitrall Model Law, which was the source for Section 2.2. If you look at Article 1.2, the wording would read that this part shall apply only where the place of arbitration was in India. The equivalent. The word only was missed out in the Indian statute. As a consequence of this, the Supreme Court in Bhatia International took the view that merely because the seat of arbitration may be outside India does not mean that part 1 does not apply. That was the case under Section 9. That was a case where an Indian party was trying to dispose of an asset and interim relief was sought. So in order to do justice, to provide the other party some remedy, the Supreme Court took the view that part 1 would apply. The inference was, and this was the ratio of Satyam Computers as Venture Global, was that if the seat of arbitration was outside India, then even Section 34 would apply. The ratio of Bhatia and Venture Global was that part 1 would apply unless it is expressly or impliedly excluded. What is an implied exclusion gave rise to a lot of litigation. There were 15 to 20, there were possibly around maybe at least 20-25 cases dealing with this issue. Finally came the decision in Balco, where a constitution bench reconsidered Bhatia and overruled it. Constitution bench took the view that if the seat of arbitration was outside India, part 1 would stand excluded. Well, seems fair enough. Fair enough, because if not, you would have Indian courts trying to set aside foreign awards. From that point of view, it seemed fine. But the problem was that in relation to Section 9 applications, where the assets were based in India, parties would have to go before the foreign tribunal and get an order from the foreign tribunal. And if that was then not adhered to, there was no proper remedy under Indian law. The parties were left remediless in a situation when the seat of arbitration was outside India, but the Section 9 application that had to be filed pertained to something where the cause of action was exclusively in India. For instance, an asset based in India. In such a situation, parties were left remediless. In relation, so the Law Commission, in order to get over this problem, made certain provisions of Part 1, like Section 9 and Section 27, which deals with court's assistance in recording evidence, applicable even to arbitration seated outside. The Ordinance has implemented this, and this is in line with the Uncitrall Model Law and laws of England as well. So hopefully going forward, the confusion caused due to the decisions in Bhatia and Balco would now stand resolved. The second issue that I would come to on judicial interventions is the fact that applications under the new ordinance would, in relation to foreign awards and in relation to international commercial arbitrations, would now lie directly before the High Court. The idea was that the commercial divisions High Court bills would also be passed simultaneously. In fact, an ordinance has been passed to that effect, and this would provide a fast-track mechanism in the High Court. And therefore, foreign awards and international commercial arbitrations would have a differential treatment, and ultimately the proceedings to challenge such awards would be fast-tracked. You may ask, why have a separate regime? The problem was caused by the investment treaty arbitral award in white industries, where the brief facts of white industries are this. There was a foreign arbitral award that was sought to be enforced by a foreign party in India. The arbitral award was stuck before the Indian courts for 10 years. Therefore, the foreign party approached the arbitral tribunal under the investment treaty between India and Australia, bilateral investment treaty between India and Australia, which provided that when a party is deprived of its effective means of a particular remedy, then it has a right under the investment treaty. It was held that an undue delay before the Indian system deprived the foreign party of its effective means clause. Therefore, this provision of directly approaching the High Court in relation to international commercial arbitrations and in relation to foreign awards was meant to provide a faster regime to avoid a repeat of the white industries saga. Thirdly, I come to the amendments to Section 8 and an amendment to Section 11 which ought to have been made, which has not been made, in relation to whether or not the test under these provisions is to be a prima facie test or a full-fledged test. What do I mean by a test over here? Section 8 deals with a situation where a party approaches the court ignoring an arbitration agreement, and the other party comes before the court and says, look here, there is a valid arbitration agreement, therefore please send us to arbitration. Don't go ahead with the hearing of the entire suit. Section 11 deals with the scenario when there's a dispute between the parties on the appointment of an arbitrator, and the other party then, which wants to go ahead with the arbitration, can then approach court, Chief Justice under the earlier regime, court under the new regime, for the appointment of an arbitrator. In both cases, the party seeking relief would have to establish that there is a valid arbitration agreement. So assuming that the other side takes an argument that the arbitration agreement is void, then would the court go into it on a prima facie basis, or would it go into it on a full-fledged analysis? The law under the earlier regime was that the court would have to go into a full-fledged analysis of it, which would often mean that parties would have the chance to raise an issue which required leading of evidence, which could unduly delay the process. The Supreme Court, in the context of Section 45, which is the equivalent of Section 8, but in the context of a foreign award, had taken the view in the Shinetsu's case that the test has to only be a prima facie test. That is, the court would see whether or not there's an arbitration agreement. The minute the arbitration agreement was produced by one of the parties, the court would say, prima facie there appears to be an arbitration agreement, which is operative. Therefore, I refer the matter to the arbitral tribunal. Before the arbitral tribunal, you can go into a full-fledged analysis as to whether or not the arbitration agreement is valid, whether or not it's applicable to the present case, whether the disputes are arbitrable, etc., etc. Unfortunately, this test was later held to be not applicable even in the context of Section 45 in the chloro-controls test. And this was in light of where the Supreme Court took the view that the decision in Shinetsu was prior to Patel Engineering, the SBP versus Patel Engineering, where a 7-judge bench of the Supreme Court in the context of Section 11 took the view that the analysis has to be full-fledged. In light of this decision, Whether it was Section 8, Section 11, or Section 45, the analysis had to be full-fledged. The Law Commission had suggested recommendations to both Section 8, 11, and 45 to make the test only a prima facie test. This was to ensure that the arbitration process is not unduly delayed. Despite the Law Commission recommendations, while the prima facie test has been incorporated into Section 8, the same has not been incorporated into Section 11. Therefore, if a party jumps the gun and files a suit and the other party files an application under Section 8, a court would have to apply a prima facie test. But if the party decides not to file a suit and goes in for and just does not appoint the arbitrator, then the other party will have to file an application under Section 11, and the court would have to go into a full-fledged analysis. In fact, this is contrary to certain observations in SBP versus Patel Engineering, where a 7-judge bench of the Supreme Court has taken the view that Section 8 and Section 11, the tests will have to be the same. Yes, there is some contradictions, because subsequently in the Lafarge case, the Supreme Court has ignored this view and taken the view that an issue of arbitrability can only be raised under Section 8 and not 11. But that aside, by and large, the principle that was set out in Patel Engineering is that at the pre-arbitration stage, the test has to be uniform. You cannot have one test under 8, a different test under 11. Now the new ordinance expressly includes one test under 8 and a different test under 11. I then move on to the fourth issue in relation to judicial intervention. This is a welcome change in Section 8. Section 8, under the old regime, was governed by the decision of the Supreme Court in the Sukanya Holdings case. In this case, the Supreme Court took the view that if a suit was filed making a party other than a party to the arbitration agreement, a party in addition to the parties to the arbitration agreement, then the court did not have the power to say, I'm referring the parties to arbitration insofar as the third party is concerned, do what you want. The cause of action could not be split, and the non-signatory could not be referred to arbitration. As a result, there were many cases where parties who wanted to avoid arbitration deliberately made third parties a party to the suit and tried to escape the provisions of Section 8. This provision, in some cases, it was a very genuine situation where there would be a bunch of contracts. Some would be with the main company, some would be with the subsidiary of the company. In such a situation, it's very difficult to say that the cause of action arose only under one agreement and not under the other. In such a situation, you would have to go against all the parties. So if you strictly apply Sukanya Holdings, you're in for some trouble. The Supreme Court, in the context of Section 45, applied the group companies doctrine and stressed on the difference in wordings between Section 8 and Section 45 as it then stood. Let me point out to you all the difference in the wordings as it then stood. Section 8 at that point provided that a judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party so applies, not later than when submitting his first statement on so and so, refer the parties to arbitration. Whereas if you look at the wording of Section 45, it provided, notwithstanding anything contained in the Code of Civil Procedure, a judicial authority, when seized of an action in a matter in respect of which the parties have made an agreement referred to in Section 44, shall, at the request of one of the parties or any person claiming through or under him, refer the parties to arbitration. The words parties claiming through and or under him was not part of Section 8 but was part of Section 45. The Supreme Court in Chloro Controls recognized this difference and applied the group companies doctrine in the context of Section 45 to say that if the arbitration agreement is only with the main company, but there is a cause of action against a subsidiary, then you can make both the main company and the subsidiary a party by saying that the subsidiary is claiming through or under the main company. This was not possible in the context of domestic arbitrations because Section 8 did not have this wording. The ordinance has done away with this situation and has incorporated the wording of Section 45 into Section 8. This is a welcome change. The fifth issue under the head of judicial interventions, which I'm going to deal with, is the Section 9 versus Section 17 issue. Under both these provisions deal with the power to grant interim relief. Section 9 deals with the power of the court to grant interim relief. Section 17 deals with the power of the arbitral tribunal to grant interim relief. Prior to the ordinance, Section 9 was far, far wider than Section 17. Section 9, for instance, could be filed even against third parties. There are a line of judgments on this. The only condition was it has to be initiated by a party. So, for instance, if you seek a garnishee order, you can make a third party a party in your Section 9 application. You do have some contrary law in some states, but I'm not getting into that debate right now. Secondly, Section 9 order was far more easily enforceable. The Supreme Court has taken the view that a Section 17 order may not be enforceable. Though the Delhi High Court has found a circuitous way in Sri Kishan's case by using the power of contempt of an arbitral tribunal. But again, these are all issues that I'm not going to be getting into because that will take us into a different topic altogether. But the result was this. Even after the arbitral tribunal came to be constituted, parties would still prefer to approach the court, even though it was the arbitral tribunal that was going to deal with the merits of the issue. Therefore, what could ultimately have been referred to the arbitral tribunal to decide in relation to the interim relief was still coming up before the courts, and this was resulting in an increase in the backlog before courts. It is for this reason that the Law Commission suggested and the Ordinance has incorporated a provision making Section 17 as wide as Section 9. This again is a welcome provision, and Section 17 has also been provided some teeth because it's an order passed under Section 17 is enforceable as if it is an order of the court. The next main topic that I would go into is the amendments to Section 28(3) and Section 34. We have a brief background. Section 34 provides a court the power to set aside an arbitral award. One of the main grounds, there are a lot of other non-controversial grounds, but one of the most controversial grounds is public policy, when the arbitral award is in conflict with the public policy of India. What is the public policy of India? This has been interpreted on many occasions. This started with the judgment in Renu Sagar, which dealt with a foreign award, where the Supreme Court took the view that public policy of India would mean fundamental policy of Indian law, contravention of the basic notions of morality and justice. This judgment in Renu Sagar came to be interpreted in ONGC versus Saw Pipes in the context of a domestic award. The Supreme Court in ONGC versus Saw Pipes widened the definition of public policy to also include patent illegality. Furthermore, in ONGC versus Sawpipes, Supreme Court went on to analyze whether or not there was a contravention of the term of the contract and used the wording of section 28(3) as it then stood. And let me read that out to you. In all cases, the arbitral tribunal shall decide in accordance with the terms of the contract and shall take into account the usages of the trade, so and so. Shall decide in terms of the contract. Therefore, a strict adherence to the terms of the contract was necessary. The Honorable Supreme Court took the view that it did have the power to go into the various ways of construing the contract, and ultimately took the view that since the patent illegality test would also include within its ambit a contravention of section 28(3). Ultimately, the patent illegality test was very widely construed, and courts took the view that misappreciation of evidence, all of that could be gone into. Subsequently, following the decision in McDermott, there was a narrowing down of this, but ultimately even McDermott took the view that ONGC versus Sawpipes could not be overruled by it because it was of the same bench strength. To make matters worse, recently, about a year and a half ago, came the decision in ONGC versus Western Gecko, which interpreted the term fundamental policy of Indian law very widely to include within its ambit the Wednesbury test of unreasonableness. This would mean any material consideration that ought to have been taken into account and was not taken into account would be within the scope of review. Any consideration that is not material that was taken into account would be within the scope of review. Therefore, this resulted in providing parties the scope to refer to each and every piece of evidence and say that this is a material consideration, this is not a material consideration, this material consideration has been taken into account. Effectively, what was meant to be a review became an appeal. But this is only one way in which you should look at the problem. The second way in which you must look at it is that such a review was possibly required because the Indian arbitration system was not mature enough for a very narrow scope of review. This is because you had certain basic issues pertaining to neutrality of arbitrators. This is something I will touch upon because the ordinance addresses this issue as well. You had most PSUs appointing their own employees as their arbitrators, and the Supreme Court in Indian Oil versus Raja had upheld this. Though there was a subsequent narrowing of the provision in Bipramaz and Denell's case by the Supreme Court, ultimately Indian Oil versus Raja still holds the field. So in such a scenario, you needed a decently wide scope of review. The ordinance has sought to do away with Indian Oil versus Raja, and as a result has also narrowed down the scope of section 34. However, I can say that there were very, very lengthy debates in the Law Commission on this. I was privy to these debates. The predominant view was that in the Indian arbitration system is still not mature enough for completely narrowing down the scope of review. Therefore, a different regime was suggested for domestic arbitrations and a different regime for international commercial arbitrations and foreign awards. In relation to the latter, patent illegality is no longer a ground for setting aside an arbitral award. But in relation to the former, the patent illegality test stands. These are broadly the provisions which deal with the narrowing down of judicial interventions. There are also stringent timelines set for judicial interventions, but I will address that a short while from now. I now move on to the next topic, which is certainty neutrality, and fairness. Let me touch upon a few of the more minor provisions before going into some of the meatier ones. The first is the definition of international commercial arbitration, contained in section 2(1)(f). International commercial arbitration, there was one ambiguity. What would happen in a situation when a company was, before I go into this, let me explain to you the concept of an international commercial arbitration. International commercial arbitration is a classification based on nationality of parties. So an arbitration can either be an international commercial arbitration or another arbitration. There is a distinction between a foreign award and an international commercial arbitration. I'm not going to get into that right now. But the primary problem that arose was what happens in a situation where a company is incorporated in India but wholly controlled from outside India. Would that company be deemed to be an Indian national? If it was an Indian national, then the arbitration would not be an international commercial arbitration. If it was deemed to not be an Indian national, then the arbitration would be an international commercial arbitration. The repercussions were twofold. One, in order to appoint an arbitrator in an international commercial arbitration in case of there being a dispute between the parties, the forum was the Chief Justice of India, now the Supreme Court under the new regime. For a domestic arbitration, the forum was the Chief Justice of the High Court, now just the High Court. There was the second consequence is the applicable law. In the case of an international commercial arbitration, parties could choose to be governed by a foreign substantive law if the arbitration was held in India. In the case of an arbitration that is not an international commercial arbitration, parties would have to be governed by Indian law so long as the seat of arbitration was in India. The uncertainty based on the control of a company was resulting in problems where on simple issues of whether parties had to approach the High Court or Supreme Court. To bring in some form of certainty, the Supreme Court in TDM Infrastructure's case took the view that if the company was incorporated in India, then it is deemed to be an Indian company, and an arbitration between such a company and another Indian company would not be an international commercial arbitration, and parties would have to approach the Chief Justice of the High Court. Well, while this brought in some certainty, the law in TDM did some violence to the language because section 2(1)(f)(3) was contrary to this. What the Law Commission has done is that the Law Commission has amended 2(1)(f)(3) so as to reinforce the law in TDM. Does not mean that the Supreme Court decision in TDM is justified, but what it means is as a policy decision, the minute a company is incorporated in India, the arbitration would not be an international commercial arbitration, and such a company in relation to a dispute which is with another Indian company would have to be governed by Indian law so long as the seat of arbitration is in India. That is the bottom line of this amendment. The second provision in relation to neutrality and fairness is deal with situations where the original of the arbitration agreement is retained by one of the parties. The other party only has a photocopy of it. I was shocked in an arbitration to find this actually happens, where a client of mine did not have the original of the arbitration agreement. So if the consequence was this: if the other party had filed a suit and we had to file a Section 8 application, we would not have been permitted because Section 8 contained a provision saying that the original of the arbitration agreement had to be produced. To do away with such a situation, a proviso has been incorporated into Section 8. Moving on to the third issue, when an application is filed under Section 9 for seeking interim relief and interim relief is granted, Section 9 now provides that a party has to initiate arbitration within 90 days unless the court expressly grants it a longer time frame to do so. This was a unique provision that was there in the Karnataka arbitration rules, which was not there in anywhere else. What was happening in most other parts of the country was that even though the Supreme Court in Sundaram Finance NEPC indicated that parties will have to initiate arbitration soon after they get interim relief under Section 9, parties would sometimes sit on their Section 9, would use that as a arm twisting mechanism and would not even initiate arbitration. The amendment to Section 9 now ensures that parties will have to initiate arbitration within 3 months. The fourth main issue in relation to certainty and neutrality is fee fixation in relation to arbitrator's fee. Section 1114 provides that rules may be framed by high courts to fix arbitrator fee. There is an indicative fee slab that has been provided in a schedule to the amendment, but this is only indicative because in various states you have various market practices. So each high court can frame rules to bring in some certainty, because today when a client asks you, what is my arbitration going to cost? It's impossible to judge. What this slab brings in is a value of dispute based fee structure. So there is some more certainty when a party is going to go in for arbitration. The fifth issue, and in my view this is the most important issue in relation to neutrality, is the introduction of the International Bar Association guidelines on conflict of interest into Schedules 5 and 7 of the new Act. I mean the amended Act. The International Bar Association guidelines contains 3 lists: the red list, the orange list, and the green list. Each of these lists spell out certain kinds of relationships between the parties, relationship between the parties and the arbitrators, relationship between the arbitrators and the council, and relationship between the arbitrators and the dispute. The IBA guidelines place some of these under the red list. Those under the red list are prohibited, and even under the 7th schedule, I think, the new ordinance says that if the relationship falls under the schedule, the arbitrator shall be ineligible to act as an arbitrator unless after the dispute has arisen between the parties agree that he can act as an arbitrator. Why did we bring in this provision in the Law Commission report? The reason was this: if red list was made waivable, and it is not under the IBA guidelines, you would have a situation wherein government tenders, PSUs would insert a clause making the other party waive their right in relation to this provision, and the condition would be you either take this or leave it, or don't get the project. So parties would be forced to sign up to such provisions, whereas parties would not agree to such an arbitrator after the dispute actually arose, because by that time they would have got the project, the dispute would have arisen in relation to the project. So a party would agree to such an arbitrator only in very unique circumstances. For instance, if the arbitrator may have had such a relationship with one of the parties, but the arbitration is so specialized that there are only 3 or 4 persons in the world who are competent. Like, for instance, if it involves a complex issue such as soil stabilization, an issue which I'm dealing with currently in an arbitration, there are very few people in the world who know a lot about this. In such situations, you need that, you can't have a blanket ban. That was the reason why that provision was incorporated. Provisions falling under the orange list, parties can consent to parties can waive. The orange list has been incorporated into Schedule 5. Therefore, insofar as Schedule 5 is concerned, This contains both the orange list and the red list, and the arbitrator at the stage of appointment would have to disclose whether his relationship with either the parties or the counsel or the dispute falls under either of these two lists. That is, falls within Schedule 5. Schedule 7 is a blanket ban, that is the red list. So overall, we are looking at a more neutral regime going forward. I will then move to the next topic, which is the carrot and the stick approach, which is aimed at improving the culture of arbitration in the country. The first most important provision is having a very strict cost regime. Even though the Supreme Court in Salem Advocates Bar Association case number 2 held that costs must follow the event, most Indian litigants and lawyers would agree with me that award on costs are rare. Most often courts say parties bear their own costs. Of late, some arbitrators have been awarding costs, but there is no mandatory rule which is being followed. That being so, this provision, section 31A, read with section 8, makes costs follow the event mandatory. What does this do? It makes the losing party bear the cost of the arbitration, and this would be the default rule. The exceptions could be situations where the winning party has made possibly 3 baseless arguments which have resulted in a waste of 3 days. Then there would be a cost allocation, and at the end of the day, the tribunal would say, while there have been 15 days of hearing, 3 days have been wasted because of the winning party, and therefore the winning party would bear the cost for those 3 days, but the rest of it would be borne by the losing party. Ultimately, this regime would ensure that parties do not put forward frivolous arguments and waste the time of the court and the arbitral tribunal. The second main incentive is a realistic interest regime. Again, it's very common that at the end of 10 years of litigation, an arbitral tribunal would award 8% as simple interest. This would provide an incentive to the party in the wrong to delay decision making. Now, by providing a more realistic interest regime, the ordinance ensures that this is done away. Thirdly, and very importantly, the ordinance ensures that the winning party can enjoy the fruits of the award almost instantaneously. How does it do it? It does away with the concept of an automatic stay. Under the earlier regime, by virtue of the wordings of section 36 of the Act, as interpreted by the Supreme Court in National Aluminium versus Presteel, and followed by the Bombay High Court and many other courts, Bombay High Court and Afcons versus Mumbai Port Trust, the law of the land was that the mere filing of a section 34 petition to challenge an arbitral award would render the award unenforceable. As a result, a section 34 petition, however frivolous, would be filed. Parties would make use of the wide definition of public policy, and the mere filing would result in a stay of the award. The winning party would not get the fruits of the award till such time the section 34 petition was dismissed, which in many cases would be at least 5 to 6 years. To do away with this, the Law Commission recommended and the ordinance is adopted, doing away with this automatic stay. Section 36 now provides that when an application is filed under section 34 to set aside an arbitral award, it will have to be accompanied by an application for a stay of the award. And to determine whether or not the award has to be stayed, the provisions of the Code of Civil Procedure have to be followed. Order 41 provides a detailed scheme in this regard, and the law in relation to the same is well settled. So, for instance, if the award provides for payment of X rupees, courts would have the discretion to say, well, I'm admitting a section 34 petition, but please deposit X or 50% of X, as the case may be. This would again provide an incentive to comply, because once the money is deposited, the party would have no incentive to delay the Section 34 proceedings. I will now move on to the next topic, which is the fast track mechanism. Insofar as the fast track mechanism, there are a number of timelines provided under Section 8 for determining Section 8 applications, 11, 34, etc. I'm not going to go into the specifics. One crucial provision is Section 29A, which is hugely problematic and was introduced for the first time in the Ordinance. It provides that parties, the arbitration shall conclude within 12 months of the arbitrators entering reference. Beyond this 12 months period, it is open for the parties to consent on a 6-month extension. Beyond this period of 12 months or 18 months, as the case may be, the arbitration automatically stands terminated unless the court then extends it. The court, while extending it, has many powers, including reducing the fees of the arbitrators, imposing costs on the parties, even removing an arbitrator altogether. Though there's an indicative timeline of 2 months given to the courts to decide on these issues, it seems highly unlikely that this timeline would be met, because without hearing the arbitrators, the court cannot decide on whether or not their fees have to be reduced. At the end of the day, this is counterproductive, as it's going to result in the respondent trying to delay, and once the 12-month threshold is crossed, the respondent is not going to agree to a 6-month extension. The claimant would have to go back before court and then seek an extension and possibly get stuck before court. There are also serious issues on the constitutionality of this provision, as 12 months is a very arbitrary time frame. In fact, the time frame of 12 months set out in Section 29A contradicts the time period of 24 months, which the very same ordinance considers reasonable for an arbitrator to conclude an arbitration. This is the period of reasonability set out in a schedule where the arbitrator, prior to appointment by a court, has to show that he is free enough to be able to conclude the arbitration within 24 months. Therefore, the Act at one place considers 24 months to be a reasonable time period to decide the arbitration, and at another place says that if the arbitration is not concluded within 12 months, it stands terminated unless extended by court. Therefore, there are serious issues on the constitutionality of this provision. Section 29B provides for a fast track mechanism. This provides for no oral evidence. The default position is no oral hearing. Parties just file written submissions. But this is not so problematic because this is purely based on the consent of parties. I would deal with one major flaw before concluding and passing it over to Timothy. There was a provision suggested by the Law Commission, Section 85(2)(a), which spelled out in great detail to which amendment should kick in at what point of time. So, for instance, a Section 9 application filed after the date of the amendment, in relation to such an application, it would be the new law which would apply. In relation to a Section 34 petition filed after the date of the amendment, the new law would apply. There was a lot of certainty. This provision has not been incorporated into the ordinance. So what is the ultimate situation then? We would go back to the default position that if there is a substantive right that has accrued, then in such a situation, the amendment cannot take away such a substantive right. In the context of Section 34, for instance, this would mean that the substantive right to review accrued on the date on which the arbitration commenced. There is certain well-settled decisions like Gerapati Biraya in the context of an appeal provision where the Supreme Court has taken the view that the right to an appeal accrues on the date on which the suit is filed. Similarly, applying the same logic, the right to review will accrue on the date on which the arbitration commences. In relation to such a provision, perhaps there can be some certainty. But the law also states, in the general position of law also states, that in relation to a procedural provision, an amendment would kick in instantly. So there is going to be a lot of litigation on which provisions of the ordinance are procedural and which are substantive. For instance, Section 11 is intended to be a procedural provision, but now the Supreme Court has a substantive right to go into the validity of the arbitration agreement. So how do you make this distinction? That is going to result in a lot of litigation. And I can tell you personally that we are already fighting some litigation, 2 cases on this ground in the short span that the ordinance is kicked in. Ultimately, I would say, looking at it from an overall point of view, the ordinance is a positive development. What we are hoping it would achieve is to inculcate a culture of compliance, which would ultimately result in parties acting more reasonably, and which would hopefully result in the other forms of alternative dispute resolution, like mediation, taking off in the country. To deal with mediation, we have Timothy, who is a young mediator with Indian Institute of Arbitration and Mediation. He's an associate at AK Law Chambers. Over to Timothy now, who's going to live up to his name because he's Gracious Timothy.
Thank you so much, sir, for your gracious introduction. Now, before I begin, as a matter of fact and a clarification, you see, the 2015 ordinance does not make any amendments to the law relating to conciliations. And that goes on the way it has been, and there is no change on that particular point. Now, the implications that the 2015 ordinance that have are rather more psychological or even strategic in my point of view. Now, much of what I want to talk about is on the premise that of this one simple question. Why would the Indian jurisdiction be interested in mediation at all? Now, we know that in most cases, the interest in mediation has been growing out of a frustration with the system of the judicial determination, or people concerned about overloading courts, high legal costs, and even the government wants to save expenditure of justice systems. Now, while all those reasons continue to be where they are, I believe that the 2015 ordinance is yet another powerful reason that will generate more and more interest in mediations. I think people are going to look for mediations considerably more than what it was in the older regime, because the newer regime does bring out such provisions that are going to force people to do that. Now, let's look at it this way. Most stakeholders have lamented over several issues and have called for greater efficiency, for transparency and accountability in arbitrations for a very long time now. Now, the fact that it is already here through the 2015 ordinance, many will definitely tend to wish otherwise. Now, why I say that is because as a practitioner, we understand that almost certainly and consistently, if I can say that, there is one party always which functions by abusing everything under the sun to delay legal proceedings and hinder them as much as they can, and therefore successfully dodging the award as long as it can be. Now, with the automatic stay under Section 34 and absence of any timelines, the potential losing party would always have a way to drag arbitration to the extent of rendering it almost infructuous. However, with the coming of this new act, the new 2015 ordinance, mediations are going to be taken much more seriously than it was before. Why? Because parties are no more going to see negotiations and mediations as a mere step just to get on with it and so that they can just get into arbitrations. According to me, mediations will be given first choice, but this time it will be on a very severe note. For example, even in the present ordinance that we have, like Section 30, which has not been changed at all, Section 30 basically speaks about arbitral tribunals encouraging settlements. I believe that with the new regime that has come into picture, Section 30 will be used far more widely, and it must be used, in fact, in appropriate circumstances in order to adjust with the new ordinance. Now, as Mr. Anirudh Krishnan has already spoken about the stringent timelines that are there, the neutrality clauses, all this is going to bring these parties on the table and take the step of mediation much more seriously than they have been doing before. I guess that is all that I have from my side. And we do have a lot of questions that have been raised by a lot of our viewers. Mr. Anirudh, Krishnan, I think in the next 20 minutes we can possibly take around 4 questions maybe. And the first question is, what is the logic behind giving the arbitral tribunal to grant interim measures even after passing the award? In that case, would it not be that the tribunal doesn't become functus officio even after passing the arbitral award? What do you have to say about that?
Yeah, see, that's a very interesting provision. It is one of a kind, but ultimately, where do you get the source of the arbitral tribunal becoming functus officio is the act itself. So if the act itself provides a carve out for the arbitral tribunal to provide interim relief, I don't see any major problem with that. In fact, well, it does go against the traditional understanding that the arbitral tribunal becomes functus officio. But in my opinion, the arbitral tribunal is in the best position to determine issues relating to interim relief because it just heard the parties on merits only.
Thank you for that. The second question is by this person, Mr. Jagdish Shah, and he has to ask you about the section 1.1, section 11, sorry. Now, as per the amendment for section 11, is it mandatory for the high courts of the states to frame rules under the ordinance? That's his question.
Well, it's not 11 does not provide for any mandatory language. It uses the word may frame rule. I'll read it out. For the purpose of determination of the field of the arbitral tribunal and the manner of its payment to the arbitral tribunal, the High Court may frame such rules as may be necessary after taking into consideration the rates specified in the fourth schedule.
Okay. So then the next question is, now we've seen that the ordinance provides a greater assistance to international commercial arbitration seated outside India in terms of availability of section 9. Now, how do you think parties can address the problem of enforcing interim reliefs that are being passed by foreign seated arbitral tribunals? Because that situation has not been addressed under section 17. How do you reconcile with this question?
See, when you have a foreign seated arbitration, you would have a foreign arbitration act that would also apply, because the default position would be that it would be governed by the procedural law of that state. Therefore, the presumption is that there would be an equivalent of the section 17 provision that is there in India in the law of that state.
All right. Okay, so we have another question from a student. His name is Anchit Tripathi, and he has been a little concerned about section 34(2)(a). According to him, even the section 34(2)(a) provides that domestic awards can be set aside on the ground of patent illegality. Now, the new ordinance solidifies this particular ground. His question is, does it not make the whole idea very backwards in nature? Are we not going backwards with applying patent illegality to domestic awards all over again, setting it aside? And why is that?
See, this was a matter which was hotly debated in the Law Commission. One view was that you really need to narrow it down. The other view was that Indian arbitration is not yet mature for this, as I was mentioning during my talk. You still have a neutrality problem. You still need that fantastic pool of arbitrators to emerge, and only if that happens can you really narrow it down. So possibly 5-6 years down the line, you need to revisit this. But today, when you are still dealing with arbitrations that are ongoing, to which this will not apply, to which the new ordinance will apply, where party-appointed arbitrators are sitting as arbitrators. You even have some situations where companies have their own standard arbitrator who sort of 50 arbitrations they do for the same company. So how can you expect a fair award in this kind of a situation when an arbitrator has great pecuniary interest in the outcome of the award? In such a situation, do you not need a wider scope of review? That was the rationale behind keeping 34(2)(a) wide enough.
Okay. And we have another question. This is a little tricky because it deals with lawyers and counsels in arbitration proceedings. Now, as per the amendment, beyond anything that goes beyond the duration of 18 months, only the courts can grant that particular extension on certain terms and conditions. Now, as per the amendment, courts can do that, but what if the counsels are the reasons why the delay of proceedings have taken place?
Well, that's very interesting. In fact, I have a problem with the whole of 29A because I think it's the completely arbitrary provision. Surprising that the ordinance has dealt with the arbitrators and with the parties, but not with the counsel. I guess the parties will have to pay the price for hiring the counsel who they hired. But at the end, and maybe you will have a regime where if a party is forced to pay its costs, it may even file a complaint to the bar council or to its counsel. Maybe that regime will emerge if Section 29A's constitutionality is ultimately tested and upheld.
Thank you so much. Now, there's another question from Rishikesh. He is asking, has Radha Krishnan and Swiss Times made nugatory? Can I refer any matters pertaining to fraud to the arbitral tribunal under the new ordinance?
There was a specific provision which the Law Commission had suggested, which has not been incorporated. Mm-hmm. So today that debate still continues. With Radha Krishnan, what is the effect of Swiss timing on Radha Krishnan, where a smaller bench of the Supreme Court has held that a larger bench was per inferium. So what is the impact? That still continues. In fact, let me draw your attention to the provision. In fact, an amendment was suggested by the Law Commission to this effect. The arbitral tribunal shall have the power to make an award or give a ruling, notwithstanding that disputes before it involves a serious question of law, complicated questions of fact, or allegations of fraud, corruption, etc. It also contained a note. This amendment is proposed in the light of the Supreme Court decisions, brackets, example Radha Krishnan, which appear to denude an arbitral tribunal of the power to decide on issues of fraud, etc. But this has not been incorporated into the ordinance. Therefore, the debate of whether or not Radha Krishnan applies, whether Swiss timing applies, that confusion is going to continue. And I am aware of the fact that even in the Madras High Court, one judge has taken the view that he will apply Radha Krishnan, the other has applied Swiss timing. Ultimately, it's been referred to a larger bench. And subject to correction has also been referred to it's also before the Supreme Court today, subject to correction.
Thank you so much. And we have another question. Let me just point it out to you for 1 minute. Suddenly become non-existent altogether? How, and specifically,
sorry, I didn't get that.
All the Supreme Court judgments that are relating to Section 11 until date, do all of them become non-existent completely?
No.
The questioner is actually pointing to specifically to provision Section 11(6)(a). He's pointing out this provision and he's asking this question about all the Supreme Court judgments that are presently in existence.
No. What it does is it restricts to an extent, it narrows down the test laid down by the Supreme Court in Patel Engineering and in Bogra Polyfab. In Bogra Polyfab, Supreme Court has come up with three categories. So first category, which has to be gone into if raised in a Section 11, that is issues pertaining to the validity of the agreement, etc. Second category, which the Chief Justice may or may not go into, like issues of whether or not there's a life claim. Third is categories which Chief Justice should not go into, that is issues of merits. What Section 6A does is it makes the position clear that the court can only go into the existence of the arbitration agreement. But as I already pointed out, the problem is that they don't make this a prima facie test. So in that sense, Patel Engineering's view that it has to be a full-fledged test, that will hold good.
Okay, thank you so much. I think we are going quite right on time, and we have still some time for the one last question. This is from Shivang, and he's from Arna Law. He's asking you, do you foresee forum shopping to be firstly a feasible option, and secondly a complicated jurisdiction tangle in the light of Commercial Codes Bill vis-a-vis the Ordinance?
Forum shopping in what sense?
Well, the question states, I'll repeat the question for you.
Yeah.
Do you foresee forum shopping to be firstly a feasible option, and secondly a complicated jurisdiction tangle in light of the Commercial Codes Bill vis-a-vis the Ordinance?
Well, that's a very, very interesting take on this, because you could have district courts which are not commercial courts, which parties may want to avoid. They may want, under the commercial divisions of High Court Bill, the Chief Justice can designate specific courts as commercial courts. And for those commercial courts, there will be specialized judges, there will be a fast track procedure, etc., etc. So I think it's a very valid point. Parties would possibly prefer going before a commercial court than before a non-commercial court. In that sense, forum shopping could become an issue at some point.
Okay, so since that was the last question, I think we are done with the session and the webinar. Thank you so much to all the viewers who have been watching and watching patiently, and thank you for all the questions, Mr. Anirudh.
Thanks, Timothy, and thanks to all the viewers. We are really, really overwhelmed by the response.
Right.
Look forward to many more webinars.
Thank you.